It's one thing to have a successful career. It's another thing to walk away from it on purpose.
Most of my clients were great. There were a few really bad apples that made things difficult, that morally weighed on me. It's hard to go to work for a doctor who you saw personally commit malpractice over and over and over and literally kill people. And it just made more sense for me to start my own thing. I was literally the only lawyer in California that was taking these infant death cases where, during labor and delivery, the nurses and doctors were ignoring horrible signs of fetal distress, in fact, making it even worse by way of medication, leading to the child's death. It's easy to work hard when you have good clients. It's easy to work hard when you really are fighting for something, fighting for your clients, fighting for justice. And we are so fortunate to be in this field of medical malpractice. Our clients need us. There are not many med-mal firms out there. They need us. And that matters so much to us that we're making a real difference.
It's one thing to have a successful career. It's another thing to walk away from it on purpose. Today's guest did exactly that. Ben Ikuta was a prominent attorney at a prestigious law firm defending hospitals, doctors, and insurance companies in high-stakes medical malpractice cases. By all measures, he had it made. But deep down, something wasn't right, and he realized he wasn't fighting for the people he truly believed in. So he made a decision most people would never dare to make. He left it all behind and started all over again, this time on the plaintiff side. Today, he runs one of the most respected medical malpractice firms in the state of California, and he's known as a leading attorney in this area of law. But more than that, he now fights for the injured, for the overlooked, for those who need someone in their corner, who need access to justice. In this episode of Art of Purpose, you'll hear how Ben found the courage to walk away from what the world calls success to pursue something deeper, purpose, and not coincidentally, success. Tremendous success also followed. Ben, thank you so much for being with us today, and welcome to Art of Purpose.
Yeah, thank you for having me. Appreciate it. I wouldn't call it tremendous success. Maybe, I don't know, somewhat some success.
Yeah. I mean, that's the humble you, and the reality is that, we all throughout the state of California now know your firm as being one of these, a leading, if not the leading, medical malpractice firm on the plaintiff side. So I say that as someone who doesn't practice medical malpractice exclusively, and that is who you guys are. So,
well, thank you for saying that.
Yeah, absolutely. And before we proceed, thank you to all of our listeners for following along, for listening to the episodes, for sharing your thoughts and sharing the episode with others. Remember to follow, subscribe on YouTube, Spotify, on Apple Podcasts. And if you guys have any ideas of any guests you'd like to see on this episode, on this podcast, please let us know, and we'll be sure to get those people on. All right, so Ben, I wanted to introduce you to our listeners. Many in the legal space know you, and there are other listeners who are being exposed to you for the first time, right? And so something beyond just what we read on the website and what we see on awards presentations and all of that. Can you talk to us a little bit about where you grew up, and we can get into maybe some things that you experienced sort of growing up, any challenges or anything, or what set you on this path of being an attorney? People don't have the same paths, and sometimes people are able to identify with these things. So tell us about growing up.
Yeah, not that interesting. I hate to say this. I grew up in Yorba Linda in Orange County, so I stayed in the area. One of 4 kids. I was the oldest, and went to UCLA for my undergraduate. Majored in mathematics.
Go Bruins.
Mathematics and economics. A double major. Not really a pre-law major.
Yeah.
And I hate to admit this, but I didn't have a clear plan in place. And I went to law school because I didn't know what I wanted to do, which is a terrible, terrible reason to go to law school.
It happens often, though. And
it does. Usually not for the better. It really doesn't. I mean, I think if you go to law school, you should have a clear plan in place. You should know what you want to do. But luckily for me, it worked out really well. And I love my job. I found my passion. Yeah. And so I'm very fortunate.
Yeah.
Went to law school at Hastings, graduated in 2008, which was the worst possible time.
Yeah, man, right in the middle of all that.
It was brutal. A blessing for me because of what happened next. I was over $200,000 in debt from law school, and then it was impossible to get a job for anybody at that time. So I took a job making $60,000 a year doing med-mal defense in Sacramento. All right, I had no ties to Sacramento, and went up there, and honestly, I loved it. I really did. I fell in love with med mal. I loved the law. I loved the medicine. And for the most part, I really liked the clients, the doctors. Didn't love the insurance companies, but the actual doctors who were my clients, I loved it. I had human beings as clients. It wasn't corporations. So, I felt like I had purpose, and it was good to get experience. I got into the courtroom. I tried cases. It was great. Should I keep going, or are we talking too much?
All
right.
Ben, this is great. No, absolutely. And you know what? I'll ask some questions based on what you're kind of telling us right now. It's interesting you say that you majored in mathematics and economics. Did you have an idea of what sort of you wanted to do, or these were just like subjects that you were interested in and that's why you majored? And I asked, for example, like our brother got a degree in neuroscience because he was sort of thinking about heading down the medical path before eventually, going to law school. So, and I think that the experience that you shared is something that's actually common and many people can relate to, right? Is, we're asked so often to make decisions at such an early age about where we're supposed to be, and we may not have any idea, right? So how did you, pick mathematics, economics, and, in the first place?
Yeah, I'm good at math. I'm good at math. I'm always good at math. And so that's why I majored in math. Yeah. I concentrated in actuarial sciences at UCLA. I did not want to leave early, so I picked up an econ major as well. And the job would naturally lead to being an actuary, which, is a good paying job, incredibly boring, at least from what I could see, right? And I wanted to be a litigator. I wanted to try cases. I wanted to, I wanted the excitement. And that's part of the reason why I decided not to become an actuary and went to law school. So kind of a weird path, but I think it's helped me. I really do. I think a lot of the math aspects, and especially with, when it comes to medicine, a lot of statistics involved and causation issues, our cancer cases especially. Obviously, we have a lot of economic issues with micro. I'll get to that later. But in my cases, we really have to work up economic damages, and it really helps to have that math background there. I've drafted calculators for my lawyers in my law firm to put together economics reports, and so it's actually been very helpful for me. Believe it or not.
Yeah, no, I believe it. I mean, look, one of the running jokes with attorneys is that attorneys are really bad at math, right? So the fact that you have this background is actually one that really helps. And as you said, particularly in medical malpractice.
Yeah. Absolutely, yes. That's how it's helped.
Yeah. All right. So you mentioned that, you didn't want to be an actuary because it seemed kind of not that exciting, but you wanted to be a trial attorney. So was that something that was in your mind at law school? You're like, hey, like the courtroom looks pretty cool and I'd like to do that.
Yes. I was struggling between criminal and civil. But to be frank, in 2008, everything shut down in both sectors. And I just had to get a job at that point. And again, I was very lucky to find, and it was a great job in Sacramento. A little law firm, doing med mal defense. I truly loved it. I really did. And then after that, I moved back to LA. I got a job in Long Beach, doing med mal defense some more. And again, really, truly loved it. I would say, I'll say this, 90% I loved. Okay. 90% of the doctors and hospitals and nurses that I represented, I loved. And it was truly an honor to represent them and to try and clear them of the accusations of malpractice, to clear their licenses. There were 10% it was hard. It was hard to go to work those days. It was hard to go to work for a doctor who you saw personally commit malpractice over and over and over again, and literally kill people, over and over again, and get them off over and over again. That was difficult, and you can't pick and choose your cases when you're on the defense side. The insurance company reaches out to you and assigns you cases. You cannot say no to them, all right? And so most of my clients were great. There were a few really bad apples that made things difficult, that morally weighed on me. And frankly, the insurance companies were pretty brutal too. They were not easy to work with. And all they cared about was the bottom line too. So it was a mixed bag, I'll say, on the defense side. Yeah,
it definitely sounds like it. Though I like what you were talking about, because I think one of some of the best attorneys are those that can also look at the other side and not necessarily see them as these horrible villains, but also understand what's going on the other end as well. And I think your experience on the defense side, I think, helped you, even in the way that you're describing it. I think is that, yeah, even both on defense and plaintiff side, there are people who are in the right. Right, on the defense side, it could be somebody who's being accused of negligence that shouldn't have to, there is no malpractice, right? That can happen as well. And you were talking about representing doctors who were great as well. My understanding is that you worked at a defense firm or defense firms for about 8 years, right?
Correct.
Throughout that time, what are some of the lessons that you learned there or experiences that have helped you? And we're going to get to you when you came over to the plaintiff side, but that sort of helped your practice and your career.
It really helped identify where you can put pressure on the defense, how to put together a demand letter or a false limits demand, what kind of discovery you can get out to really put pressure on the defense, how you can get two defendants to point the finger at each other, when you're suing two different defendants in a medical malpractice lawsuit. Also, in medical malpractice, there's only 5 carriers really that insures 90% of all doctors. Really just 2 that has over half. And so specifically as to those insurance carriers, I knew all the ins and outs and exactly when they would do things, how they'd do things, when they would pay, what would get them nervous. And so that really helped me significantly. When I switched sides to the plaintiff side. In medical practice, it's very specific. It's different than general PI. Every case is litigation. And I know exactly what motions to file, how to put pressure on the defense and on insurance companies.
Yeah, no, absolutely. And, since you mentioned that, I want to give you sort of a little bit of a space here to talk and educate our listeners as well, right, on what is medical malpractice in and of itself, right? Because it is different from, let's say, an accident case or even a catastrophic injury case that's not in the medical malpractice area. What is, if you can explain to listeners, sort of what is this area of medical malpractice and why is it difficult in California in particular? If you can bring your mic a little closer.
Yeah, no problem. The biggest, it's a good question, and there's a lot of differences between medical malpractice and general PI. I'll start with this. In general PI, an insured consent is not required to settle a case. So if you have Geico or AAA and you get in an accident, it's your fault, they can settle your case without your consent. When it comes to physicians, any settlement over $30,000 has to be reported to the Medical Board of California. $10,000 for dental cases. Any amount, even 1 penny, gets reported to what's called the National Practitioners Data Bank, which is a data bank that hospitals and medical groups have access to. So when you settle a case as a doctor, that could have a material impact on your license, on your future employment prospects. I mean, it could be a big deal.
Right. They don't want that on the record.
Exactly. So for those reasons, doctor consent is required before an insurance company is allowed to settle that case. It creates a situation where they are much more heavily invested in the defense of their own case. They're prepared thoroughly for days before they're deposed and before they testify at trial. And for those consent reasons as well, our cases go to trial a lot more often than in general PI. And for similar reasons, in a PI case, you can tell typically who's at fault. Maybe not always, but you can see police report, a rear ender, you can know who's at fault, right? In medical malpractice, it's a lot more complicated. Even a case that you think is simple, a retained sponge. Well, whose fault was that? The hospital's fault, the doctor's fault,
And that's different avenues of who you have to go after.
Exactly.
Who it doesn't.
So even those cases, they don't resolve prior to filing a lawsuit. You still have to do the investigation, the discovery, the depositions, et cetera. So our cases, they take a while before they do resolve. And for whatever reason, I don't know why, jurors know. I mean, you're not allowed to bring up insurance in trial. We all know that.
That's an evidentiary rule for all our listeners. You're just not allowed to mention that in trial.
Yeah, you cannot bring up liability insurance. But jurors know that, there's car insurance, auto insurance involved.
Sure.
For whatever reason, they don't know about medical malpractice insurance. So you're suing a good doctor, right? I mean, they just, they really feel like, how is this verdict going to impact the doctor? That could really hurt us as well. Doctors come off well.
Right.
You know,
Because people just think, hey, they're trying to help and do good, and mistakes happen.
it's almost like a reverse reptile, right? You know, jurors don't want to believe that their own doctors would hurt them or their loved ones, right? So it almost gives the doctors a benefit of the doubt. It requires us almost to prove more than preponderance of the evidence. And then, you know, lastly, just jurors don't feel qualified. They don't. They feel qualified to judge bad drivers.
Right, because they do it.
Because
they drive and...
Or bad employers.
Right.
You know, they're employed, right? Or you know, crimes. They don't feel qualified to judge, you know, the performance of a surgery that they've never even heard of, right? So it can be very difficult. That's why statistics show that in California, which is, you know, a blue state, that over 83% of all cases that go to trial, that make it all the way to trial, in med-mal, result in a defense verdict.
Wow.
So it's hard. It's tough.
Yeah.
I think I answered your question, right?
Yeah, no, absolutely.
Okay.
And so I think those are that's definitely one of the biggest obstacles or barriers when we're talking about medical malpractice cases. There's also the issue of just damages, right? Can you talk to us a little bit about the limits on damages?
Yeah.
And how that affects how cases are litigated and how you have to litigate cases and how defense carriers or attorneys litigate cases.
Yeah. It's a law called MICRA. It's not just a cap on damages. There's a series of different laws that are all doctor-friendly that really hurt patients. But this law puts a cap on emotional damages. There's no cap on what's called economic damages. So if you get hurt, you can't work anymore, or you need future care, you can still put together, you can still, you know, recover as your damages your lost income or the cost of your future care. But when it comes to emotional damages, that's capped. And that cap was placed in 1975 in a law called MICRA, okay? The Medical Injury Compensation Reform Act of 1975. Yeah. And that law set the cap at $250,000, okay? Which back in 1975 was worth, you know, well over $1 million in today's dollars, right? Yeah. That law remained unchanged until very recently. So even though, you know, it didn't get adjusted for inflation, so it stayed at $250,000. So if you lost a child, right, or if you're a stay-at-home mom and you died, those cases were capped at $250,000. It made it so that just economically, most law firms were not able to take those kind of cases. Yeah. There had to be a big economic component to it. So either a patient who was catastrophically injured but not dead, you know, brain damage, paralysis, amputation, or a case of a high wage earner, right? So I hate to admit this, but it's true. Just economically, our cases over the years tended to skew towards white and male. We had to, because white males made more money. And when they passed away, we could put together economic reports that, you know, that would make the case worthwhile.
Substantial, right.
Exactly. Just do the math, right? If I had a case, and I'll get into this later, but if I had a case where a child passes away, right? Let's say a child dies due to egregious malpractice. This was 3 or 4 years ago. And the most I could get in the case was $250,000. The average cost, when it comes to me trying a case, the average amount that I spend, it's about $120,000, okay, with the experts and everything else.
Yeah, because these medical malpractice cases are expensive to litigate.
Yeah, every element of a med-mal case has to be proven by expert testimony, which are very expensive. These experts back in 1975 cost $100 an hour. Yeah. Now they're $1,000 an hour. Right.
And you have to pay them to have them as a part of your case to be able to present your case. So it's something for our listeners that, you know, maybe this is not something that necessarily is needed in every other types of cases, but in medical malpractice, in every single one of them, it's necessary. Exactly.
So do the math, right? And the jurors don't know about the cap. They're not aware of the cap. So my very first trial on the plaintiff side was a child death case, an infant death case, where I won. I asked the jury to give me $460,000 because I couldn't get over $250,000 anyway. I didn't want to insult the jury. I could have asked for millions. The jury gave me more than what I asked for, gave me $500,000, and the judge cut it down to that $250,000 number.
Because of the law.
And do the math. $250,000 minus $120,000 in costs. Now there's $130,000 left over. My fee was $40,000. The client doesn't even get $100,000 for the loss of a child.
Yeah.
And the offer in that case from the defense was zero.
Yeah.
and it was a 12-0 verdict. The reason why they weren't making any offers was because they knew it would cost me that kind of money. And again, there's only a small handful of med mal carriers. They wanted to dissuade us from taking the next case, knowing that economically, it's impossible for me to spend hundreds of hours of my time and $120,000 of my own money to make a fee of $40,000 and to give my client $90,000 for the loss of her child. So it was pretty bad.
Yeah.
And you mentioned in the beginning of the podcast that I'm one of the premier med mal firms. Well, frankly, it's by pure luck because so many firms got out of the game.
Yeah.
So many firms could not do this area of law anymore because of that cap. And so there weren't, and there still are not many of us that do med mal because of those caps. Now, the good news is that the caps finally went up. Should we get into that?
Yeah. Go, please.
Yeah,
Tell us,
and thank you to CAOC, to Nick Rowley,
Right.
to others. It's been a huge change and a huge game. It's a game changer in the industry. It's enormous. It's still not justice, but it's certainly a lot closer than it used to be.
Yeah.
And now the caps are in 2023 they went to $350 for a living plaintiff,
250,000.
and $500,000 for a wrongful death case. And it goes up $50,000 every single year for wrongful death and $40,000 for a living plaintiff. So now it's $600 for a wrongful death case, and it's $430,000 for living plaintiff.
Yeah.
So $600,000. I mean, it's still not justice. It's still not right when you lose your child due to horrible malpractice.
Yeah.
But at least it's viable. At least now they're making offers. At least now there's at least some way to get a lawyer in these cases. I was literally the only lawyer in California that was taking these infant death cases where, during labor and delivery, the nurses and doctors were ignoring horrible signs of fetal distress, in fact, making it even worse by way of medication, leading to the child's death. I was the only one taking those cases because of that cap. But now they're more viable. And so now now there are more lawyers doing it, which is great, finding justice for victims of malpractice.
Yeah.
I spoke way too long there. I apologize.
No, this is perfect, exactly what we want. And this is what happens when we have an expert in an area of law who's able to explain this, right? And I think the reality, Ben, is that most people don't know about this. They don't know that there's a cap. They don't know. And so you're right. When they hear about a lawsuit against a doctor or they're jurors and they come into a trial, they're just thinking, well, here's a good doctor trying to do his best. And, why are people going after them, right? But the reality is that malpractice does exist and it does happen. And even so, there is Ben was talking about a cap, meaning there's a ceiling on the amount of damages a family can get for the death of a loved one. And while it has increased, it's still not fairness. It's far from fairness.
Yeah, and that's another reason why our cases go to trial, right? When it comes to personal injury, the threat of a multi-million-dollar verdict really pushes insurance companies and corporations to offer fair amounts, or at least fairer amounts, right?
Yeah.
Because of the cap, there's no downside for these insurance companies to fight us all the way through trial, or at least right up to the courthouse steps. So another reason why, a lot of our cases end up in trial, or it's tough. It's tough.
Yeah, absolutely. And Ben, speaking about that, I think this brings us back to the conversation that we were having. Is that a big part of what you do, because of this difficult area of law that is really the law is heavily favoring the defense and hospitals and insurance carriers, that you make a switch to the plaintiff side, and that you provide access to justice to people, right? Who otherwise wouldn't have it. You mentioned that you were the only attorney at that time taking these infant death cases. Well, that is providing access to justice to people, right? And so there's something beyond just, we're attorneys, we're making money. Now, this is something that became a passion and purpose for you as well. Can you talk to us about that switch to the plaintiff side? I know that you mentioned that 90% of the people, the doctors that you worked with, it was pretty good, but that 10% really was difficult for you on the defense side.
It was eye-opening going to the plaintiff side. It was eye-opening. On the defense side, I just assumed that if there was malpractice, that the case would be filed. Because honestly, I saw a lot of frivolous cases.
Yeah.
I shouldn't say frivolous, a lot of meritless cases, right? A lot of times there's a bad result, the patient dies or gets hurt, and it's not really anyone's fault, right? Just because a bad outcome happened doesn't mean there's malpractice. And even if a mistake happens, it doesn't mean it's malpractice. Mistakes can be reasonable, right? And so I'd say about half of our cases on the defense side were, meritless cases where the doctor did everything right, or made a reasonable mistake. I would say 40% were those where a good doctor, but like a rear ender, that one time they made a bad mistake, right? And I still had no problem representing those doctors, and frankly, those doctors would settle the cases. They would know they screwed up. They would provide consent, and we would settle the case, and it wouldn't be a problem. It was 10% that was a problem, where these doctors who thought they were God were killing patients over and over and over again. And the problem is, these 10% often had other medical board issues, and if they had a medical board issue, they were less likely to settle because they couldn't afford.
They didn't want that on the record.
Exactly. And the worst part was, Michelle had a trial last year in San Bernardino, actually, where a doctor was, suspended for a year for allegedly, but a lot of evidence that he did this, molesting a 12-year-old patient, and had other med board issues as well. And he committed clear malpractice, but he couldn't afford another strike against his license, so he refused to settle the case. And so we were forced to go to trial in a small podiatry case, but there was clear malpractice. Yeah. So those are the 10% that I had a problem with. When I went to I just assumed that cases would be filed if there was malpractice. When I went to the plaintiff side, I realized that there were simultaneously, well, I'll say it this way, the wrong cases were being filed, right? There were some cases that shouldn't have been filed, but plenty of meritorious, strong med mal cases, but because of the cap, weren't being filed. We had to say no to. A great example is this. This is still
great.
I hate saying this, but it's true, and it's our lesson today. In fact, I got a case on the way here that I rejected for this. Any, let's say, ophthalmology or optometry case leading to the loss of one eye, we reject immediately because it's just, when it comes to medical malpractice, loss of an eye would be invaluable in a personal injury case. If you get in a car accident and lose an eye, that'd be worth a lot of money. In medical malpractice, when you lose an eye, there's not much economics that go along with that. You can still drive, you can still work, right? So it's almost a pure capped case. And so for that reason, we can't take those kind of cases. But there are cases where absolutely misdiagnosis of a spinal stroke or very poor performance of LASIK, where people lose vision in one eye. So we would see these cases not being filed. But fortunately, again, because of the more recent changes in the cap, those cases are at least becoming a little more viable.
No. And Ben, and for our listeners, as Ben is talking about this, for those who may not know entirely this just a legal background here, it's that let's say with the loss of an eye, with the cap, the ceiling on general damages, meaning any compensation for pain and suffering or anything that goes along with that, since it's only $250,000, when you think about it, that's really where the value in a case like that is. It's in all the loss and the emotional damage that come with having lost an eye. And so because it's capped at 250, or it was capped, it's increased a little bit now, but it's still not sufficient. Those cases are very difficult to litigate because they're still just as expensive as the other ones. And going back to the example that you gave a bit earlier, is that it doesn't leave the client with much anyways at the end, or the firm. So it doesn't make it in terms of business viable to pursue, and it doesn't bring much recovery by anything to the plaintiff, and it'll take 2, 3, 4 years to litigate.
Exactly. And a lot of personal injury lawyers and clients don't understand. The cap is not like an insurance limit. The cap is a hard cap. It's the worst case scenario for the defense, for the insurance company, right? So, and they know that economically it's extremely hard for us to take those cases, right? So they're incentivized to offer far less than the cap when it comes to settlement offers. oftentimes zero.
Yeah.
I mean, I think over my last 9 trials, I received an offer in 1 case, and that includes 5 wrongful death cases. And that one offer was $30,000. So we get plenty of cases where the offer is zero. Michelle, my partner, is in trial right now on a death case in Orange County, and the offer is zero. So it's very common for us to not get any offers from the defense.
It's like they feel like they're playing with house money, basically.
There's no threat. There's no. I mean, they're not going to lose for millions and millions of dollars. They can't under the law. Even if a jury awards $10 million,
It's gonna get
the
cut
judge
right
is
back down.
required to cut it down to that low cap. So it does make it difficult. But again, the change in the law has helped. It has helped significantly, and we have been able to take cases now that we were not able to take previously.
And so you go to the plaintiff side and begin to notice that there are some cases that were meritorious but were not being filed. And as you spend time on the plaintiff side before opening up your own practice, were there any sort of like lessons that you took from that period? You became a named partner at the plaintiff firm that you started working at. Sort of how was that period for you? And people don't always think about opening up their own practice, right? So how was that experience for you, having switched to the plaintiff side?
A prominent lawyer offered me a job based on a case I had against him. I beat him in trial in a case, and again, no offer case.
Yeah.
And he was impressed with me, and he hired me. His name's Dan Hodes, a very prominent lawyer down in Orange County, and a phenomenal lawyer. I learned so much from him, and
cool.
and it was a wonderful experience. I made named partner with him after 5 years. And I repaid him by almost immediately starting my own firm after that. I learned a ton from Dan, and how to handle. I mean, I learned how to handle med mal cases on the defense side, but now I saw the plaintiff side and how to pick a good case and how to work them up. Learned a ton from him. I knew Michelle, my partner now. I met her at the defense firm in Long Beach. We worked together. I knew how good she was and how hardworking she was and how smart she was. So my first move as a named partner with Dan was to bring on Michelle to our firm. And
Nice. Yeah.
and then, as much as I love Dan and Jeff Millman, who were just wonderful mentors, wonderful partners to me, and I'm so eternally grateful to them. And they're still very supportive of my firm.
Yeah.
They still send me
That's the
cases.
best.
They're wonderful.
That's the best.
Still, they're in their mid-60s. I'm a little bit younger. And it just made more sense for me to start my own thing.
Sure.
And frankly, too, I don't know how to say this, but my goal was to be Dan Hodes.
Yeah.
That was my goal. And and even with my name on the wall as a third partner there, I would never be Dan Hodes, being hired by Dan Hodes and working for Dan Hodes. Yeah. So I that's part of the reason why I want to start my own firm too.
Yeah.
So
that's cool, Ben, and thanks for sharing that. I think so often sometimes people don't express that, and that's perfectly fine, right? I mean, we can have goals and ambitions and the things that we want for our life, and those things are great, right? And so I love that, sharing that. It's like, hey, look, I wanted to, have that level of success or acclaim as well and be able to help all those people. And this was the move for me to do. When did you decide, kind of when I know we were talking before we started the podcast, and that having your own practice is not something that you had anticipated or had even planned out necessarily. How does that become maybe a desire for you and something that's, actually feasible and doable?
Yeah, good question. Michelle helped me a lot. I mean, Michelle really pushed me out of the nest. I was.
This is Michelle.
Michelle Hemesath, my partner. I'm sorry.
For our listeners.
She's
great.
She's wonderful. I mean, I have a lot of thoughts here. Yeah, my original.
And please tell us. Yeah. Because it's helpful as well for folks. You know what I mean? Like finding the right partner, business partner. Man, people sometimes go through many different iterations of businesses because it's not the right person, right? Or it wasn't the right partnership. And, I've seen you guys, and seen you guys from afar as you guys have grown, seeing you guys interact in person. I've spoken and spent time with Michelle. She's amazing. And like the partnership makes absolute sense. So like the fact that you guys came together and chose each other to go into this business, like that's actually something that's very valuable. And any insight into that is super helpful for people.
Yeah, no, here's what I'll say. I was looking a little bit around, for different partners, other med-mal lawyers, people. I tried cases with other prominent med-mal lawyers that were about my age. And we had discussions about starting our own firm together. Part of me wanted to stay with Dan and take over his practice because, I was very, very loyal to Dan Hodes and Jeff Millman. So it was hard for me to make that decision. When it comes to a partner, it's like a marriage. It really is like a marriage. If there are any warning signs at all, do not pick that person. I just need to emphasize that. Like, just like a marriage, sometimes people foolishly, they can see an issue, they know it's there, but they say, you know what, these other things will compensate for that. It'll be okay. No, it will not be okay. All right. Do not ignore the bad warning signs. Make sure you pick a partner, if you do partner with somebody, who has good credit. Okay, that's important.
Yeah.
We have a credit line at my firm. We have to fund our cases. Right now, we're $3 million deep in case costs at my firm. Okay, it's extremely expensive in medical malpractice cases when it comes to working up these cases and hiring experts. Not quite as bad as in PI, but still, there's still cost there. Not just case costs, but your firm costs, your rent, everything else. Your advertising costs.
When it's your name and it's your firm, it all comes back to you.
Yeah, and having good credit really. I mean, I know it's very specific advice, but it's important.
This is helpful
because
they
they will ask you for your credit and your partner's credit. Whoever the owners are at the firm, they want to know what your credit is when it comes to extending credit lines. So that's really, really important. Michelle, so hardworking. She's extremely driven. She's very, very smart. But most important, I just know she's a good person. She cares about her clients. I know that she would never, ever, do anything that would be dishonest or just, when it comes to her clients, the practice of law, or to me, right? Someone I can absolutely trust. I trust Michelle more than anybody else. So when it comes to picking a partner, it's like a marriage. You cannot ignore warning signs. I would advertise. I would recommend not having a partner over picking the wrong one. Obviously, it's a risk. That's the biggest concern, right? When it comes to people starting their own firm. But take the plunge. If you're on the fence, take the plunge. Yeah. I mean, when it comes to just the financial benefits from it, when it comes to the freedom, I still work as hard as I did before. Sure. I really do. I work harder, actually, but my hours are more flexible. I can do things with my kids. I can, take a day off here and there. So there's a lot of freedom. If not having a boss, it really is helpful, right? It's trying cases too. I mean, that matters too. When I tried cases on the defense side and early on with Dan Hodes, it's hard to try cases with your boss, right? Even when you're doing a direct or you're doing an opening statement or you're picking a jury, having them write down notes and really them critiquing your work and being nervous and having to feel like you have to do it their way, that really impacts your ability to try a case. When you own your own firm, you could do it your way, right? It's important to learn, of course. It's important to get the experience before you start your own firm or before you get into a courtroom. But nonetheless, it's helpful not having that, that pressure from a boss sitting next to you. And Michelle and I don't have that. And frankly, our lawyers don't have that either. We're all the same age, and so we go in there as colleagues, as equals. We always try cases in pairs, by the way. That's not really relevant to your question. Other advice. I'm very fortunate here, and maybe this is not applicable to a lot of your listeners or to you, but I think having a niche has been huge for Michelle and for me.
Yeah. You guys are known as medical malpractice attorneys.
Exactly. We have a lot of referrals, and we have a lot of cases, and that really helps significantly. We don't have to advertise. So I think even in the PI world, people foolishly don't concentrate on an area of PI. Now, listen, if you're going to a general bar association or your neighbors, your friends, of course, tell them you do personal injury, But if you're going to a personal injury event, You're not going to get cases if you say I do personal injury,
Everything. Mm-hmm.
right? Say, no, I specialize in the prevent doctrine. I specialize in Uber and Lyft cases, bicycle cases, trucking cases. I specialize in slip and falls. Find an area that that you can, for that one case you did a good job on. Use that as your niche is what I recommend. That way you can get more cases in the future, or get lawyers to call you to collaborate and work with you and to co-counsel cases.
Great advice.
Write articles on that. I mean, if you look at on your desk here, I can see it's magazines from different organizations. It costs an arm and a leg for these firms to be advertising in these magazines, because people read them and see them. Well, guess what? You can get free advertising by writing an article, right? And those are often read a lot. They're read more often than the advertisements are. So write articles. Write articles on that niche. Every single one of my articles, you can see it on my website, has the phrase micra or medical malpractice in the title, because I purposely concentrate on my niche, right? And then it's Googleable too. People will Google these issues in medical malpractice, and my name will pop up. I have more advice.
Yeah, no.
Okay.
Yeah,
all
please.
right.
This is all really, I think, insightful and helpful for people. Yeah.
If you do have a niche that's like ours, like medical malpractice, if you're workers' comp, if you're lemon law, if you do that kind of stuff, in our signature blocks we put in medical malpractice attorneys. Okay, so that when people in their inboxes type in the word med mal or medical malpractice, my name pops up because of all of the emails I've sent out. Right, we constantly respond to med mal specific inquiries in different groups. Like CALA or OCTLA or COC. So we're constantly getting our names out there. We're very good at that. And we've learned a lot from you. We've copied your lead when it comes to the sponsorships to schools and to children who going to college. And so we've learned that way too, to put our money where it's best spent, not only to provide maximum exposure for us, but to help the community as well. I have a lot more thoughts, but I'll ask you later.
No, this is great. Ben, you know what? It's one of these where, we talked about you making the transition to having your own practice, and then comes the question of, oh, this is not just the practice of law now. There's also a business, and like, how do we get this business going and keep it going, right? Because you want it to be an enduring, lasting business and not just something that's ephemeral, right? That is temporary, or that it was good for a few years. And so it's all these questions that pop up about marketing, about making yourself known, about how to handle the money, about how to structure, about how to begin hiring, about how to set the culture within a firm, right? These are all great. Is there anything else that I feel like I almost like cut you off here with that? But if there's anything else that has popped up over these first few years as you guys have been running your firm, or advice that you would have for folks.
We have 7 lawyers now. So Michelle and me, and then 5 other lawyers. We have, I think we have 16 staff. When it comes to hiring lawyers, again, in the personal injury world, you got to be a little bit careful, right? If there's any warning signs, don't hire that person. Where we hire is from the defense. And why that's a big advantage is because we can see firsthand the work product, right? And we actually create a list. We have an Excel spreadsheet or a Google spreadsheet where we have a list of those lawyers young lawyers that you've been out 5 to 10 years, where we've been impressed with their work product, their deposition skills, and we will target those lawyers to hire. So that's how we pick our defense.
Cool. Yeah. That's smart.
Yeah, and for them, I mean, it's a great change. They love the change. The lawyers that we've hired, they went from representing the defense, but more importantly, the insurance carriers are a nightmare to deal with. I mean, claims reps are awful. Going from that to us, where we don't have the billable hours, we don't have the carrier reports, we don't have insurance companies, and our attorneys get trial experience. Michelle's in trial right now, again with one of our other lawyers. So they get the experience they wouldn't get otherwise too, and the money is better too. So that's how we hire our lawyers.
That's great. I like that. That's really smart. And you understand those people because that was you.
Exactly. Yeah. And then for our staff, we do not require them to come to the office. We let staff work from home 100%, and we have staff that we have a wonderful paralegal who lives in Hawaii. We have another paralegal who lives in Idaho, where minimum wage, by the way, is like $9 an hour or $8 an hour. And we pay her a lot more than that, obviously. But she's very happy and very loyal to us. We have an attorney that lives in Portland, Oregon, who I used to work on the defense side with. So we have people that, and frankly, if people live in Riverside, right here, it would be impossible for them to commute to Orange County, right, every day. So letting people work from home has been a big competitive advantage as well.
Yeah, I think that's exactly what it is, right? It's a competitive advantage. You're providing something that other firms aren't necessarily providing, or as as accepting of, and the work product remains at the highest of levels.
Yeah, exactly. Yeah, our most recent hire, we hired a wonderful paralegal who Michelle and I knew from over a decade ago, 15 years ago now, from our time as defense lawyers, and she was making a pretty brutal commute from Diamond Bar to Long Beach, which was 50 minutes every single day, and she's getting paid handsomely by the defense firm. And she reached out to us, and we told her we can't pay you what you're being paid now. We offered her a job at a $5,000 pay cut, and she immediately took it and works with us now because to her, working from home was worth it.
It's a lifestyle.
And for us, we don't lose the camaraderie. We really don't. We have these Zoom calls once a month. We have these firm days where we take off half a day.
Those, on Instagram,
or we go to a movie, or we go bowling or an escape room, or we spend half a day together. So we still feel we have the camaraderie. Frankly, if you have a bad employee, man, they're going to work. They're not going to be good at home or in the office, and vice versa. A good employee will be good no matter. You don't need to babysit them, So it's a big deal for our employees. Can I go on?
Yeah.
I mean, imagine that you're an employee, who lives in Diamond Bar, right? And have to go to Long Beach every day. That's 50 minutes each way. It's almost 2 hours you're wasting. It's putting on your makeup. It's getting dressed. It's buying food because when you go to the workplace, it's all these other costs. It's your car insurance. It's your gas. It really, really adds up to an enormous amount of money for these people to have to commute every day. And so I would highly recommend that lawyers allow their staff to work from home. It gives you a huge competitive advantage.
And I hear you talking about all this, and it's really cool in the context of our conversation so far, where you told us earlier that it's having your own practice not something that you had ever considered, right? And you open up your practice, and now your thoughts are also consumed in addition with all these other things, right? How do you create the type of culture that you want? How do you provide the environment that makes people want to come? And it's a competitive advantage as well. And as I think about this stage now in your life that you're well into, and you think about the clients that you're helping and the access to justice that you're providing, how do you see your role in the legal space and in your community at large? Because I think, as I mentioned, access to justice is something that you guys are providing, and that goes beyond just what we see on headlines. It's also the firm that you guys are creating. And so I guess part of what I'm asking is, going back to this idea of purpose, is that, and you mentioned it earlier, that you arrived at your purpose, right?
Yeah.
And how do you feel today with that, and how all these things that have happened around your life have helped you lead you to that?
That's a broad question. I will say it's easy to work hard when you have good clients. It's easy to work hard when you really are fighting for something, fighting for your clients, fighting for justice. And we are so fortunate to be in this field of medical malpractice where our clients need us. There are not many med-mal firms out there, and they need us. And they know that too, and they're so appreciative, and that matters so much to us that we're making a real difference. I'm still friends with a lot of my former clients. I just saw one last week with her little boy, who was harmed severely by malpractice at his birth. We went to Chuck E. Cheese together with my boys.
That's sweet.
And we still send birthday gifts to our minor clients. We still stay in touch with them because they're our friends. We've gone through so much together, and so it's wonderful. Honestly, I'm so blessed to do what I do. It's wonderful. And it's a perfect job. I'm so lucky.
Yeah.
And not just with the clients, with having Michelle and the rest of my firm too. It's a blessing.
Yeah, no, absolutely. We've spent some time outside of the office. We were able to spend some time at different conferences. We've golfed together.
We attempted to golf together.
Yeah, that's the best way to put it. Actually, we did attempt to golf. We hit the ball somehow.
Sometimes I did.
Yeah, you better than me. But I would describe you just to anybody that I'm meeting. It's like, yo, Ben's a fun guy. Like, he's really cool. That would be
look
at your face. But
you gotta be honest, man.
You're also like what I like about you as well is that there's been, you're fun, great hang, but you're also very serious when it comes to your clients, right? And part of what we see today, for example, is that you get serious when you talk about these things that you're very passionate about, right? And they matter to you. How in kind of carrying the burdens and all the things that your clients are going through, how do you, so on a day-to-day, how does that experience go for you? I think, people, represent different types of clients. It might be difficult for them, even like in their own lives, carrying the burden. How does that, for you, day-to-day, carrying the difficulties of all your clients, as an attorney, has that been difficult for you? And how do you get through that on a day-to-day basis? With the understanding, as I mentioned, like I've always known you to be a great guy and a fun guy, right? But you're also carrying a lot of weight.
Of my clients?
Yeah.
We're so blessed. I mean, when you see a client I have a client right now. She's 37 years old, beautiful, 3 young kids, married, husband's an awesome guy. Case out here in San Bernardino, and they didn't diagnose an epidural abscess timely, and now she's, a paraplegic, really quadriparesis. She can really move only one arm. I mean, it just makes you feel so blessed that, that we're healthy, that you can, but it also makes you feel, it's a burden, man. It really does. You want to do so well for them, and you want to work your butt off to make sure that you can get the most you possibly can for them to get some level of justice. And it's really hard in this field with these caps, but I don't know. I think I answered your question, right?
Yeah.
It is a big weight, and it does bear on you. It does keep you up at night, but it's also that much more rewarding when you're able to get a good result.
Yeah, no, absolutely. Well, Ben, I thank you so much for taking the time to come with us today. I know that you had just come from an event with your children. You were busy. You had a very busy week. You were telling me about your week earlier or before we started the podcast. And I know you're a really busy guy. So thank you for making the time to come out here and talk about you and talk about your practice.
Yeah, thanks for having me.
And again, to all our listeners, thank you for following along. Thank you for subscribing. And we're just going to ask you guys to continue to share your thoughts, comments, and any ideas that you might have for guests. Thank you for being with us on this episode of Art of Purpose, and we'll see you on the next one.